Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. You'll notice in the back of me there's the nice Christmas owl, so you certainly know what time of year I'm doing this. I wish everybody happy holidays, happy New Year, and so forth. What is it that I'd like to talk about today? Well, I'd like to talk about qualifying relatives for waivers. And you might be asking, well, what is that and why would you make a whole video on that particular subject? Well, let me tell you, there are a lot of people that are inadmissible for, for one reason or another to the United States. This means that because of what they did, basically, the United States doesn't want them to come in. Okay, and there's all kinds of grounds for inadmissibility. It ranges from people who are convicted of all kinds of crimes or even admitted to committing those crimes, ones involving crimes of moral turpitude to violations of different kinds of laws or controlled substance violations. There's different issues regarding how many they may have occurred. There's trafficking, meaning trafficking in both drugs and also alien smuggling. There's misrepresentation and fraud, money laundering activities. There's various health-related grounds, and I mean, this has nothing to do with crimes, except they're still inadmissible for various reasons because of the health-related grounds, unlawful presence, public charge grounds, security-related grounds. So on misrepresentation and fraud, if I didn't already say that. So, there's lots of different grounds that people are inadmissible. However, on a lot of different types of those grounds, the law provides what's called a waiver, okay? And a waiver essentially is basically saying, I know that I'm inadmissible because of this or that reason, please still let me in. I mean, that's the bottom line of what the waiver is. I mean, it of course takes a lot of work to prepare and get the attorney cover letter and legal brief declarations, affidavits, all kinds of stuff. But that's the bottom line of what a waiver is. Now, the reason that this particular video is on one element of this is that there many times is a requirement that there be a qualifying relative, which you may or may not need to show hardship, and of course sometimes there's not even a requirement for a qualifying relative. However, a qualifying relative is somebody of a particular relation that you can show exists, and then of course you follow the requirements for the particular waiver as to whether or not you need to show hardship and how you need to show it and so forth. And so it is critically important that when doing the waiver, number one, you have to see whether or not it's a requirement to have a qualifying relative, and if there is, what is the burden to show of hardship and so forth, in order to have a realistic chance of doing the waiver. So the next question, people always ask me is, well, what about this case or that case? What is the requirements for, whether or not there's a qualifying relative, and then what do you have to show? So let's go over just a few so you can get the idea of how different it is, and that a waiver is not simply a waiver, okay? Let's start, for example, health-related grounds. And again, this could be either physical, with a communicable disease or various mental disorders and so forth. I'm not getting to the point of showing what you need to show to prove the waiver, only concentrating on the point of the qualified relative issue, okay? So I could clear that up. So in health-related grounds, you being the foreign national need to be the spouse or unmarried child of a United States citizen or lawful permanent resident, or the parent of a United States citizen or lawful permanent resident. Now, in this particular case, it goes both ways. Whether you're the child or the parent or so forth, it's fairly liberal. And also in the health-related ground waiver for qualifying relative purposes, you only need to show you have a a qualifying relative. That's it. There's no need to show hardship. There's no need to show anything, no burden at all, just that you have the qualifying relative on either side. So that would be it for the health-related grounds. Now, what about another ground which is very popular, unfortunately, and it's also very difficult to get approved, but it's when there's fraud and misrepresentation. Okay? In this particular case, the foreign national needs to be the spouse, son, or daughter of a United States citizen or lawful permanent resident. Now, note, in this particular one, you cannot be or have a child only that's a U.S. citizen or lawful permanent resident. That won't work. You cannot show all the hardship your child's going to suffer if not allowed back in. Let's say that you came into the United States with a fake green card, and let's say that you have 12 children. Okay. Unfortunately, that is not going to help you. And you could be married, but let's say your husband or your wife is here unlawfully and has no legal status. In that particular case, you don't qualify for the waiver because you don't have a qualifying relative. And then even then, let's say you do have the qualifying relative, it's much harder to get the waiver than with a health-related ground because you have to show hardship to the qualifying relative, and there's different ways that you can show that, such as showing the presence that the USC or LPR family ties in the United States, showing the qualifying relative family ties outside the United States, show the country conditions and and the country of relocation and the qualifying relatives country ties outside the country, show financial impact of departure, significant health conditions, especially, for example, when there's not suitable medical help in the foreign country, and then you can show other relevant factors, including the impact of separation, economic and other conditions, show the emotional, cultural, political conditions of the foreign country, the quality of life factors. You can show the extreme hardships if the qualifying relative stays in the U.S. and you're separated, and also if the qualifying relative moves with you to the foreign country. So, as you can see, to show the hardship on a fraud and misrepresentation case, it does take, of course, quite a bit of work, and you do have the qualifying relative relationship that you have to show. Now, what about another big ground of inadmissibility? That would be criminal. Okay, criminal-related grounds of inadmissibility. So, what qualifying relatives exist, and what's the burden of proof? Well, you first have to look and, of course, make sure that the crime itself qualifies for the criminal waiver, and that's a whole nother video, okay, which I've done on that. But let's assume, for argument's sake, that it does qualify. Okay, so assuming it does qualify, then you have to look and see when was the crime committed. Okay, look and see how long ago the crime was committed from the time that the visa application or adjustment of status is being done. Okay, now if the crime was more than 15 years before the date of the visa application, admission to the U.S., or adjustment of status, then you don't need to show a qualifying relative. Okay, you basically need to show that the admission would not be contrary to the national welfare, safety, or security of the U.S., and that the foreign national has been rehabilitated. And of course, you have to show rehabilitation. You show a good job, good family, going to church, volunteering, helping old people across the street, things like that. You would be able to show, if the crime's older than 15 years, a much easier burden in order to get the criminal waiver granted. So of course, if the client comes to me and they have, a crime that was committed 18 years ago, it's no problem. I mean, not that it's no problem, but the form of the waiver is a lot different. If they have a crime that was committed 14 years ago, I might look at that crime and the factors of the case and might say, well, look, we'll prepare it, but we're not going to file it for another year, because the chances of you winning are a lot higher after the 15-year mark. Okay? So let's assume that the crime is earlier than 5 years. What do you have to show then? Well, then you have to show that the foreign national is the spouse, parent, son, or daughter of a United States citizen or lawful permanent resident, and that USC or lawful permanent resident would suffer extreme hardship if the foreign national is not admitted. And again, you show all kinds of factors and so forth to show the extreme hardship. So in this case, in this particular case, you can have children, like the example I gave you earlier with the fraud waiver, where you can't show the hardship to the children. In this case, you can. You can show that, and show all the hardship they're going to suffer, whether they stay here or go with you. And in fact, sometimes when I'm doing the fraud waiver, where you cannot directly show the hardship to the children, what basically I do is I show the hardship. Let's say there is a qualifying relative, such as a spouse. You show all the extra hardship the spouse will suffer because of the children. I call it, you bootstrap the hardship of the children to the parent. Well, in this particular case with the criminal waiver, with crimes less than 15 years old, you can show direct hardship to the children. So if your next question, or if a question is, well, how come with the fraud waiver you can't show hardship to the children, but with the criminal waiver you can? Well, I have no idea. You need to ask Congress that, okay? The ones who passed the law. It honestly doesn't make any sense, because the people who are going to suffer the most, realistically, are the children. And yet with a fraud waiver, you can't show that. So maybe one of the reasons is because they view misrepresentation and fraud in a worse light than they do crimes. And it's their way of trying to persuade people to not commit fraud and misrepresentation. That could be a possibility. Well, anyways, that is the general rundown of qualifying relatives and what is and isn't needed in regards to hardship. So what I would suggest is, of course, if you're inadmissible on some ground, give me a call. I will be able to give you a consultation, let you know, number one, if you're inadmissible, number two, if a waiver exists, and number three, if you qualify for the waiver, and then number four, if we can find a way to minimize the type of waiver that you might need to give you a better chance to enter. Okay, well, go ahead and like my video if you do like it, and subscribe to my list. I put out videos once a week or so, and I will have more videos in the coming weeks. Thank you.